Finally, some good news. One of the critically awaited cases decided at Supreme Court level just made breaking news. The Supreme Court has surprisingly upheld the 1978 Indian Child Welfare Act, which aims to prevent Native American children from being separated from their families and placed in non-Native homes. The law requires states to involve tribes in foster care and adoption proceedings, prioritizing placement with the extended family members of the child's tribe or other Native American families. The decision comes after some challenges, of course, from Republican-led states and white families, surprise, surprise, who argue that the law is race-based and unconstitutional. Even more surprisingly, Justice Amy Coney Barrett, writing for the majority, acknowledged the complexity of the case, but also said that all the challenges to the statutes were rejected. Justices Thomas and Alito dissented, expressing concerns for the rights and interests of the children involved. Surprise. The Indian Child Welfare Act was enacted as a response to the rates at which Native American and Alaska Native children were removed from their homes by public and private agencies. It is intended to preserve Native families, their traditions, and of course, deeply rooted cultures. The lead plaintiffs in the Supreme Court case that kicked all this off were Chad and Jennifer Brackeen, who adopted a Native American child after a legal battle with the Navajo Nation. They sought to adopt the child's half-sister, who has been living with them since infancy, but the Navajo Nation opposed the adoption. That is what turned into this legal case. The case involved children, of course, also from various other tribes, including Navajo, Cherokee, White Earth Band of Ojibwe, and other tribal nations. Opponents of the Indian Child Welfare Act argue that this is unconstitutional, claiming it prioritizes tribal interests over those of the children's and grants excessive federal government control in areas traditionally under state jurisdiction, such as adoption and foster placements. However, more than 3/4 of the 574 federally recognized tribes and nearly 24 state attorney general offices from across the political spectrum urged the Supreme Court to uphold the law. So finally, something bipartisan. This is not the first time that the court has considered cases related to ICWA. Previous cases in 1989 and 2013 have also, of course, resulted in a political spectacle. Prior to the law's enactment, a significant number of Native American children, between 25 and 35 actually, were removed from their families and placed with non-Native adoptive families in foster care or in institutions, oftentimes with the idea of whitewashing and assimilating them. The decision to uphold ICWA is finally a piece of good news of late. And maybe if SCOTUS can now favorably decide on Moore v. Harper and eventually also the student loans, well, we might actually get somewhere.